the language used in the legal process between the legal professionals and members of the public. Or legal professionals include anybody in the court or outside the court. So this legal professionals and members of the public is generally referred to in the field of forensic linguistics as language and the law. That would include encounter with the police, being questioned in the court, uh, and other situations, like for example, if you are even if you're talking to your own lawyer, that would also include and would come in language and law. Certain areas of research have emerged in language and law, that is lawyers' introductional styles and how these can vary according to the expected empathy or objectives of the questioned witness. That is, how a lawyer poses a question would depend on what does a lawyer want. So that can, increase the empathy. So questions like, that that person was very close to you, and when he died, so how would you feel, or what was the feeling, or now you are orphan, or something like that. So the lawyers' interactional styles would determine what would be the outcome and whatever objectives they have. So that is also the part of research. The right to silence, we've already discussed this issue in the class in Miranda laws. So it is like the right to silence, like you have option that you should not say anything, but still there are people who are going to ask you questions, like police officers who are going to ask you questions and probing something. So this also comes in research area. The semantic ramification of the changes made to the right, that is any change which is related to the right, that we have already discussed what is the meaning that they want to communicate. The linguistic performances of witnesses, that is how they are performing in a certain situation, whether it's court or whether it's outside the court, or whether it's the member of the group. So for example, if it's anything to do with the government, or anything to do with some criminal case, so according to that, its linguistic performances are evaluated. The occurrence of verbaling in the witness statements, that is like when there are two stages of a case which is developed. One is that when a person is asked to write something down, that what did they see on that day, or what were they doing on that day, so that it can be compared with something that they say later on. So this is also something that you can work on as in language and law for research. And the practices involved in the process of determining a person's language of origin. This we have also discussed in the class, that in authorship you need to look at it, that how a person is communicating, and what do you guess from the kind of vowels they are using, or the kind of conversation they are having, or the use of the, or we have discussed it in the last lecture as well, that the use of the normally before certain words or certain phrases indicate that the person is not the native speaker. So that is also the part of research emerging in language and law. Power in legal context, especially in the courts. So this dealing with the law part, that is anywhere it is involved within the court, it is the power play, it is the game of power. So if you look at the courtrooms, its lawyer is exercising some kind of power over the other lawyers, or is trying to exercise the power over the other lawyer in the form of language, or maybe the jury is exercising power over someone. So this all is a power game which is going on in the legal context. So that's what we look at over here in this section or portion. The manifestation of this power is first seen as a restriction of movement. So restriction of movement is a physical movement. That is, the movement of a person is restricted. Let's suppose we look at the courtroom, and in courtroom every person is assigned their special places, and they cannot move from those places. So this is something which is like kind of exercising power. They've given you the example, that is, if you don't like how you are being treated, you're not free to just walk away from police station. So this is the power that like government or our law, that is constitution, does not give this right that if someone is treating us bad, we can just walk out from there, especially when it comes to police stations and courtrooms and such places. So this is exercising power. And as we all know that in foreign countries, it's still a bit ethical the way they treat you as compared to how they treat you here in Pakistan. So in foreign countries, it's not very physical, it's more verbal. However, here in Pakistan, it's more physical. So this this may vary. That is this it may vary from country to country, the way they treat you. So it's not just Pakistan, but in many other countries, it's like more varies from verbal to physical harm. Okay, so power is defined as the capacity of one or more persons to produce intended or foreseen effects on others due to authorities, manipulation, persuasion, or any kind of other force, which can be physical as well in certain scenarios. So in when we are talking about courts operate with their own set of rules. There's no such thing as your personal rules, or the rules that are set by someone else. So they have their personal rules, and you have to follow those rules when you are there. The primary source of the power balance between a layman, ordinary person, and the legal professionals are of two types. One is situational and one is linguistic. However, they both overlap when it comes to the analysis. Situational powers are, we've already talked about it a little. That is, situational power ensures that witnesses are obliged to attend and perform as instructed. That is, when they are in courtroom, there are certain things that they need to follow. That is, they need to sit there, physical presence, and they have specific place where they have to sit, and they have to follow the same rules that are predetermined, and everyone is aware of that. However, this everyone may change if someone, a foreigner is, for instance, going to a courtroom in India, then obviously it's going to be different for them, because they don't have that cultural knowledge of how to act or follow the rules in the courts of India. The situation power also endorses the lawyer's linguistic power, because that's how they exercise power over anyone in situation power as well. And the way they frame questions, that automatically forces the situational power. So it's kind of overlapping. That's to make the situational demands at the same time. It's like through linguistic forms. And when we compare the same courtroom, same situation for a layman, then it's completely different. Or even if it's a witness, it's completely different. They don't exercise any power. So even a layman has no power over there. It depends on the lawyer to control the situations. However, it may vary from court to court, because we have different types of courts. And then talking about different types of courts, it may vary. Even the authority and the power of lawyers may vary. So but majority of the time lawyers are the ones who are controlling, and they are controlling at every point in the courtroom, in the procession, whatever is session is going on, of the witness's testimony, to even to select the topics. That is, whatever a witness wants to say, from that point to the point of selection of the topic, what they are going to talk about, that all depends on the lawyer. So sometimes it is not the lawyers, it's the judges as well, because it is within the lawyers and the judges' control to determine whether the witness has to respond or not, whether the witness will be allowed to give an answer or not. Even they are not allowed to retaliate or say something, like if they want to object, sometimes it is not even allowed. So it depends on the judges whether they want to allow it or not. So that's a very important point. Even though the crime narrative to be presented through each witness testimony is ultimately the product of the answers given to the lawyer's question, the form and content of the information permitted in each witness testimony is in the hands of the questioning lawyer. Testimony is created in two forms. I've told you before that it is like written form as well, that once they ask them that, what have you done, or where were you, or what do you think, and they write a statement. However, one is created when they are sitting in the courtroom and these proceedings are going on, and lawyers asking question, or judges observing, or even asking a question, and it can be possible that even two parties are communicating with one another, and that's how the situation is created. The question answer session, through question answer session, it's created. Please read excerpt 13.1 in your books. The interesting part, the very interesting part with the lawyer's skill is that they are actually aware of the facts of the case, so they are already prepared. Now they are capable of asking questions in different ways, and the way they ask question and what they want. So sometimes in order to encourage a witness to give a more positive response, so they can say, for example, by using some, they can change it to any, or by using any they can change it to some. If you read these two excerpts, did you have some alcohol, or did you have any alcohol? What's the difference between these two? The difference is that with any, it's like the possibility is that there was none. However, with some, the possibility is that already alcohol is proved. So psychologically, even if the witness is trying to avoid this answer, they might say something. So that's how they pose the questions. So we can say that questions are asked by someone who knows the answer, and it is asked from the person who knows that they know the answer. That is the witness. That's the communication which is going on. Then the question is, where are the true addressees? The ones with the legal professionals need to convince in order to win their case. That would be the jury or the judge. They are only the silent observers. According to the research, it is said that this dynamic is a form of fictive interaction. Why fictive interaction? Because this word fictive is taken from fiction, that is, story is created or something which is staged, a drama. So, what is happening in the courtroom? It is like two people have prepared themselves, that is, lawyers are already prepared and have practiced it time and again in maybe domestic courts or other types of courts, or maybe in some internships. They have already practiced it, and they know how to pose questions and how to elicit response from someone. However, a witness is only mentally prepared. They don't have any kind of practice. Whereas jury is actually sitting as a spectator. They are only looking at them, how they are communicating, and then towards the end deciding what is going to be the verdict. So the courtroom trial is a kind of a play that a silent jury is watching in order to give their verdict. There are two types of court system. One is adversarial and the other one is inquisitorial. Now, in adversarial, which is also referred to as inquisitorial, we have some set of questions, that is, system of questions that runs. So, for example, it is in America and Britain and Australia. However, when it comes to inquisitorial systems, that involves one or more judges where they have to take the decision. That would also depend on the kind of a case. We'll discuss it in detail in the later slides. Okay, so as I've told you before that there are a set of questions that we asked in adversarial courts, and that is, it is normally between the rival parties, and both the rival parties are actually present over there, and they present their respective arguments and evidence and are entitled to question each other. However, here we do not try to dig out the truth, but we basically, it's about winning. It's about winning. Who wins, right? The dueling party are generally divided into two, that is the crown and the accused party. The crown is normally the state or the prosecution, or and the accused is the defendant, who is represented by the defense counsel. So accused is the one who's considered to be guilty. And what is happening in the adversarial system is also described as embracing procedural truth, which assumes that the truth will emerge from a collaboration between the two parties. However, it's not the case. It's just assuming. The system is about winning and not revealing the truth. Language researchers have illustrated the disparity between the notion, and they say that a witness should be able to tell their story in the court, and how little of the testimony they are able to contribute due to the power constraints. So these are the two issues. Why? Because we have already discussed that it's the power play. So whether they'll be allowed to contribute or whether they'll not be allowed to contribute. So, and if they are allowed, would the witness be able to share their story in the court or not? Inquisitorial courts, they are different from the other one. That is, all the questioning is done by the presiding judge, who direct the bulk of all questions, and lawyers are not in a lot of power. They are normally in the passive role. They are passive when it comes to these kinds of courts. Lawyer can only ask questions after the judge has completed their questions, and that too only to answer to get the answer from whatever the judge has already asked. So procedurally, this court is substantially different from the other, because the accused is the first to testify. In the other, it's not the case. The testimony is developed through the conversation which is going on between the two rival parties. So it's like they have not made up their mind that this person is there is this concept of presumption of innocence. So they presume that the person is innocent, so therefore there is a quarrel going on, or argument going on between the two. The duel is going on. However, in Inquisitorial Court, they already determined that the person is guilty. That is, there is no such thing of presumption of innocence. We think that if this person was not guilty, then this person or this trial would not be happening right now. So it's like they've almost already made up their mind. In such courts, judges are very strict in linguistically saying that judges are very strict in following the appropriate register. So even the witness is forced to maintain the appropriate register, which would actually determine the trial outcome as well. Situational features. We have already talked about situational features, that is the physical presence or how the power is used in such scenarios, so especially in court. So power imbalance is amplified actually by the situational features. And what are those situational features? Such as, first of all, the court layout, which we have already discussed, the size and the mass of the court furniture. Typically the witness is in focus position where all eyes are on him or her, and they're in front of everyone. They sit between the judge and the jury and clearly visible to the rest of the court. The judge is typically seated higher, and the bench is generally constructed of more massive wood, which is creating a kind of environment where this is showing that the person is already in power. We know who's in power over there. So this is something which comes in the power imbalance. More serious the crime, the greater these differences are prone to be. That is, maybe the person is not coming to the court just like without chains. So these are the things like that would enhance the situational features in power imbalance. Okay. However, in lower courts, this is not the case, because in lower courts, the person is going to be sitting right, beside the lawyer, and you might have seen it in different movies. When a witness is called by either the prosecution or the defense, they are supposed to be, going to be examined by a friendly lawyer or by a cross-examined by the hostile one. So, either it's the good lawyer, or either it's the one who would ask you very difficult questions and would be very harsh in asking questions. And that might not be, always true, because the prosecution's primary responsibility is to construct a credible case against the accused. So if the prosecution does not choose to call the witness, the defense is under no obligation to do so. So if, for example, as we've talked about it before as well, that if someone is not called, then it's like it is not possible, because they have to construct the case. As I've told you before, that testimony is created through the case, how it goes on. So question answers, and then it goes on, and it's the case is developed and more data is added so that the verdict could be given. Okay, so how lawyers ask question, it is like it is said by the researchers that the lawyers' use of questions are as a weapon that serve to test or challenge claims made by the witness, or they can be also called as vehicles to make acquisitions, to or to be used to elicit empathy from the jury. For example, the use of we is like referring to something which is more uh, strategies of an us versus them kind of a pattern. And when referring to a defendant by a nickname, or their personal names, as opposed to refer to the witness by the title plus surname, or only simply surname. So these are the things which show, these strategies show an us versus them pattern that can encourage empathy with or against someone. If you look at the example, there are certain types of questions that lawyers ask. So if you look at this example, can you tell me what time he arrived? Here in this question, the main clause makes this a yes and no question, and you have to answer it through yes and no, or you can add some lines from the respective question after yes and no, or you can answer it without any other word and just yes and no. But a cooperative witness will likely to respond to the embedded question, that is, what time. So the kind of a question that they pose are very tricky. If you look at this question, anyone would try to answer what time rather than can you tell me. So if you read this question for the first time, can you tell me what time he arrived, the very first thing that comes to your mind is I have to answer what time he arrived. However, the question is, can you tell me? You can answer it as yes, or you can answer it as no. That's how lawyers ask questions. Lawyers mainly use sentence function category, which is either interrogative or declarative. When it comes to interrogative, then they start with the auxiliary, that is can you or will you, or they sometimes add it with the question words, that is how, when, where, why, such questions. And when it comes to declarative, they are making the statements, which typically begins with the subject, that is you did. So when it comes to interrogative, it can be like you know like the question that we have already discussed, that is can you tell me what time he arrived. However, if it is the other way around, that is the use of how, when, where, and why, the question can be, for example, how are those gates operated. So you are actually asking the person that how something is done. These are the two types. When in declarative, they are normally the statements, which actually is simple statements. They just tell you what happened. They just ask you that this happened, or add a tag question to that. However, sometimes lawyers use both declarative and interrogative statements, and uh, I'll give you an example. So it can be, for example, that they seem to be very quiet, polite people. Agree with that? So here, the lawyer is asking uh, um, a a question, but both techniques are used. Interrogative and declarative both are used. They seem to be very quiet, polite people. Agree with that? So basically it starts with the statement and it ends with a question. And another example, and you and Mr. Y, I suppose, were accepted in that flat, right? And then that's a question. It's a statement and then a question. And so that's how you go for a statement and a question, both in the same. There are different types of answers that you receive. So because the area is very vast in that, so we will just take a just view of that. The answer types are divided in like minimal, elaborated, or evasive answers to the questions, as as well as it can be somewhere where the witness is giving no response at all. So when the witness is given an opportunity to answer or not, the respondents normally answer and use a strategy like, for example, I don't know. So technically they have given an answer if you look at the statement, but at the same time they are refusing to say that we don't want to answer. So if someone says that I don't want to answer this question, technically it is leading to something very serious. However, if someone says and gives an answer and says that I don't know, it's a technique that they are using. So they have given the answer, yet they haven't said anything. Sometimes the full range of answers given during examination, where witness appears to claim more of their testimonies with elaborated responses when questioned by the hostile lawyer as opposed to the sympathetic lawyer. So it was investigated and research was conducted, and the study shows that normally elaborated answers are given to the hostile lawyers and not to the sympathetic lawyers. However, it's not always the case. With regard to the answers actually given, most responses are minimal responses. The minimal responses are yes and no answers, or the answers which may require the element of restrictive WH question. So it's basically no answer that you are listening to. It's just like yes or no. Maybe it's of some importance to the case. However, it depends on what the question was. There are certain disadvantages, linguistic disadvantages, which comes when it is where we are talking about law. And the two primary areas are investigated in this regard. The first one is that language speaker norms that contrast with the expected language norms of the court. So if, for example, someone is used to swearing, which is not allowed in the court, and a person can be punished for that. So this is something which is which can be an example of that. And the court translations and interpretation. If you remember, we already discussed one case of in investigation where we studied about Miranda laws, and there was a Russian lady, and I actually discussed it in detail. So it's like translations are very important, or interpretation is very important. You must have an interpreter. However, the interpreter might not be communicating the way you communicate in your language, and that becomes the disadvantages when it comes to law. Moreover, you may also be also have disadvantage when it comes to the culture. Like, you do not know about the culture of the court. What could be the culture of the court, how you will respond to that, what kind of language do you need to use, or what is considered bad and what is considered good, even when you're answering some questions. So in Pakistani context, let's suppose if a man is asking his wife not to go outside because something is, you know, bad outside, so it's fine in Pakistani context, it's considered, you know, positive that the person is taking care. However, in foreign countries it might be considered as something which is bad, maybe maybe in a negative way. So if someone isn't aware of that, then it becomes a linguistic disadvantage, because if they are using such structures in a sentence or using such topics in a sentence, then they are at disadvantage. Uh, Plus, if you don't know the language properly, if you're not proficient at the language and you are communicating, you may say things which are which may add up against you.